All right, how about now? Okay. All right, when you hear your name, please step up to the podium that is in the center of the courtroom in here. At the end of your hearing today, you're going to be receiving some paperwork, and that's going to go over everything we cover in here. That does include your next court dates as well as all of your release conditions. So you don't need to memorize that information as we're going through it. For those of you who will be out of custody prior to your next court date, I do recommend contacting the court in advance of that date to verify your hearing details. You can also check to see if there are other ways of appearing, since some of the courts are still allowing for virtual appearances for some hearing types. Please keep in mind, you do have the right to remain silent. Everything you say in the courtroom is being recorded, both audio and video, and could be used in a potential future court proceeding. All right, are we ready to start with Mr. Rem, or are they not set yet?
I cannot.
Ready to go? Okay.
You can leave the hoodie on, just take the hood off. Yeah.
Yeah, with all of it.
Take it off.
Just wait.
Joe right here.
All right, good afternoon. Mr. Rem, if you could go ahead and state your full name and date of birth, sir.
Joe Rem, 08/11/2002.
All right, and if we could do appearances from counsel. Let's go and start with defense, and I know we've got Mr. Noteware on Teams.
Good afternoon, Your Honor. Mark Adair, Suzuki Law. I'm entering a limited appearance for purposes of today's only, so out of an abundance of caution, I would ask the court to also appoint the public defender, and then if we are fully retained, we'll do a substitution of counsel.
Understood, thank you. All right, Mr. Noteware?
Thank you. Good afternoon. It's Rick Noteware for the state.
All right, thank you both. And sir, you are here for a new case out of Superior Court. The charge that has been submitted is one count of murder in the second degree. That is a Class 1 felony. Mr. Noteware, I did not see the date of offense in here because the date of offense was doubled up with the arrest date. Do you know what that correct date is?
Thank you, Your Honor. Your Honor, I attempted to submit to you a couple of different documents. One is the November 11th, 2022 Form 4, which was a basis for probable cause in the initial arrest for this matter. It identified that date of offense, and I was hoping that you received that. Your Honor, I'm also hoping that you received 3 different statements from next of kin in this matter. Were you able to receive those?
I did receive the 3 victim impact statements. I did not receive the other Form 4, but actually, and I didn't realize there was one in our system. I'm pulling up that right now so I can take a look at that.
And certainly I would be asking the court to accept as a supplement then the Form 4 that was submitted then on November 11th of 2022. The statement prepared by Detective Smith is actually a supplement to the matter that was in November of 22. The hope is that the court will understand that it was previously submitted, it was under oath at that time.
Understood. And I do have the offense date. I'm going to consider this old Form 4. I'm not reading the PC statement within it, but I will consider it with respect to just the offense date only, which is in here as November 10 of 2022. All right, with that being said, before I get to court dates and release conditions, I know we do have some individuals here who it is my understanding is next of kin to the victim in this matter who do want to address the court. Mr. Noteware, I'm assuming you want them to go first before you address the court with respect to release?
Thank you, Your Honor.
All right, let's go ahead and unmute that. I did receive the 3 victim impact statements that were prepared and submitted to the court here today, but if you would like to go ahead and address the court with what you want to let us know regarding release.
Yes, my name's Mark Jacobo. I'm Stephen's father, and based on my form that I filled out, he doesn't belong on the streets. He doesn't belong to be released. He shouldn't get a bond for the impact that he's caused my family, my son, and even all the people were there that got to witness what they saw. with the amount of gun violence that has been everywhere daily, he doesn't belong on the streets. He doesn't belong. It's been very set in stone that he has committed this crime and he needs to pay the price.
All right, thank you, sir. Anything further?
No, ma'am.
All right. Anyone else that needed to address the court back there? I can't tell who all's back there at this time.
Yes, this is Alma. This is Stephen's mother, and I also agree. He doesn't need to be out with the public and be out with the community and do what he did to us, to anybody else's family. I don't want anybody to go through what we are going through right now. I want him to be behind bars as long as possible so he doesn't hurt anybody else.
Thank you.
All right, thank you both. And no one else?
No, no, ma'am.
All right. Thank you both. I know it's difficult coming in here and speaking on record.
I appreciate it.
All right, Mr. Nowhere, let's go ahead and start with you if you want to go ahead and address release in this matter.
Thank you again, Your Honor. In November of 22, the court determined that a $1 million bond was appropriate for the release conditions for Mr. Rim. At this point, recognizing some of the other issues and certainly the statements of the family and otherwise, my submitted form to the court indicated a $500,000 secured appearance bond would be appropriate in this matter. I am not in any way understating what it is that the next of kin have gone through. The concerns from the court, the concerns from the state include issues such as we do believe, based on information belief, that he has a prior juvenile record that does include assaultive behavior, and the police officers indicate that there are prior arrests and prior convictions. They may have been as juveniles, and I've not been able to confirm those at this point. We have been able to identify additional witnesses who have come forward and presented information for the state to be able to proceed with the charges in this instance. We certainly believe that a significantly high bond in this matter would be appropriate. Thank you, Gary.
Higher bond.
All right, thank you. And Mr. Adair, anything you want to let the court know?
Thank you, Your Honor. I would first start out by saying I certainly would agree with the state that there is nothing that I could even begin to compare with the family's loss in this particular case, and I am not insensitive to that. However, I would like the court to be aware that obviously these are just an allegation at this point in time. I think it's important for the court to realize that this case goes back to 2022. I've been involved in the case since 2022. I believe this will be the third go from law enforcement to provide a submittal to the prosecutor's office. The previous two times they've been turn downs. So the fact of the matter is that my client has been on the streets in the community ever since this is alleged to have occurred, and there has been zero law enforcement contacts. There has been zero arrests for any violent contact. There has been zero convictions, felony or misdemeanor. Part of the duties of this court at this stage is obviously to protect the community and society, and I understand that. But I think that that is a body of works, if I could characterize it as such, that you don't typically see, because this has been turned down at least twice, and this is the third effort. I don't know if it's a sensitivity on behalf of East Mesa law enforcement with everything that's going on right now, and you know, this arrest on a Friday. I have sent out letters to the charging bureau of the county attorney's office. I've sent out letters to law enforcement, including the detectives, saying we are fully cooperative. You want to make an arrest, we'll do a self-surrender. We do them at our office every single week. And, you know, I understand they're not obligated to take me up on that, but I just want this court to be aware that our office has been involved since 2022. Those efforts have been extended. Those letters let the interested parties know that we will be cooperative. And that has not been, we've not been taken up on that. So here we find ourselves before the court because Mr. Rim was arrested last night, last evening. Heavy presence, SWAT team, all that. I think it was totally unnecessary. But with respect to this particular charge, I again do not take lightly the fact of what the nature of the charge is. But I've been around long enough, and I certainly know Mr. Hotwer's been around long enough back in the days when we had bond matrices for the types of crimes and that's how bonds were based. That is not how we do business in this court now. And in terms of his risk, and I've not seen, I didn't see the victim impact statements prior to addressing the court now. I've not seen a public risk assessment score or anything like that either. But I think when you take all that into consideration and the fact that this case has had a tortured history thus far, that I think even the $500,000 requested bond by the state is too much. It's precluding my client from, and again, he's lived at the same house the entire time, Judge, from his job, whether his family's going to have the financial wherewithal to meet any bond. Obviously, that still has to be addressed when this court imposes those release conditions. But I just want the court to know that this is something that Mr. Rim and his family have been dealing with as well, albeit from a different perspective, but have been dealing with it since 2022. I don't know what has changed. I believe I was present at the last arrest and that argument that was before the court at the initial appearance. I'm sorry I don't have that in front of me, but I think I was. But I would suggest respectfully, Your Honor, that given the information that I'm giving to the court now, and again, I think it's considerably different than what would normally be before the court, that a secured appearance bond, no more than $50,000 is more than enough to show that there's financial stake in it. And the court certainly has other tools at its disposal to assure further community safety, such as pretrial services with electronic monitoring. It's not going to be a problem for Joe. Again, he's been in the community for over a year now. There's been no issues whatsoever. So I don't want that to be an overstated part. But the court, I believe, has tools available to address those concerns as well. He does live at home with his folks. He's lived there continuously. He graduated high school here. He's working jobs here. He's going to come back to court. And if we're wanting to assure him to come back to court, I understand the financial aspect of it. Again, nothing higher than $50,000 I think is more than enough to handle that. And again, with those other conditions, if the court still has those concerns, and again, trust me, I'm very sensitive what the victims are saying here. Thank you.
All right, thank you both. Just one moment. All right, in considering release in this matter, I have considered the positions of both parties. I have considered the statements submitted by the victims or next of kin in this matter. I've also considered Mr. Rim's prior history, which does include a prior juvenile history, which does include a prior violent offense. I've also taken into account the effect on both the victims and the community with this type of gun violence can have. I've also taken into account the strength of the evidence that's been submitted to the court today, which I do find does rise above the probable cause standard in proceeding here today. I've also considered the fact that at the time of the event, you left the scene of the offense prior to the police arriving, that you also allegedly came back to pick up a casing, which I can only assume was because you were attempting to cover up the actions of that day. I have also taken into account the time frame. I do understand that obviously the fact that it's 2 years later makes no difference to the victims in this matter. I'm sure it's still just as fresh and the offense is just like it happened yesterday for them. But I have taken into account the effect that you have not run, that you have retained counsel and appear to have been following up on this offense, but I do still have to take into account the certain penalties that you are facing if you are convicted in this matter.
Yes, ma'am.
So for that reason, I do believe a bond is appropriate. I am setting a $750,000 secured appearance bond. If you post that bond, you are going to be subject to the supervision of pretrial services with electronic monitoring to be installed prior to release. You're going to be ordered not to have any contact with any alleged victim, complainant, or witness in this matter. You're not to possess any weapons while on release. You're not to possess any drugs without a valid prescription, possess or consume alcohol. And in this matter, when I say no victim contact, that does include any next of kin that would be recognized under the victim rights laws of the state of Arizona. In this matter, I do have to set some court dates. At this time, there is a status conference set January 25th and a preliminary hearing January 29th, both at 8:30 at the downtown Phoenix Superior Court. All of this information is going to be provided in paperwork that will be available to all parties. Mr. Room will give you a set as well as provide your attorney with that. And for the record, since I didn't say this earlier, I have appointed the public defender's office since I only have a limited notice of appearance at this time. Now that we've gone through that, is there anything further that either party would like to add? Mr. Noteware, anything from the state?
Thank you. No, Your Honor.
All right, Mr. Adair.
No, Judge.
All right. Thank you both. If you want to go ahead and step up, thank you for coming in today. All right, before we move on to our next matter, I do have a warrant that I need to address here. It is going to be just one moment. And Mr. Nowhere, you're welcome to sign off.